without prior permission in writing. Now, because of your conviction, you're disqualified under both federal and state law from purchasing, possessing, owning, using, or having under your control any firearm, ammunition, or dangerous ordinance. To do so would subject you to being prosecuted under both federal and state law for a felony. You're not permitted to have any of those or any other weapons of any type while you're in under community control in this case. You're not permitted to purchase, possess, use, or have under your control any kind of controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance has effects similar to those or drugs of abuse, nor any instrument, device, or thing that may be used to administer those or prepare them to be administered, unless you have a lawful prescription. You must provide a copy of that within 24 hours of receiving it. You are to submit to drug testing when and as requested. You're not permitted to purchase, possess, use, or have in your control any alcoholic beverages, nor may be present in places where they're sold or being consumed, even if otherwise lawful. You're not to associate with any co-defendant or any other person who has a criminal record, a member of a gang, or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless approved in writing by your supervising officer. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any contact law enforcement or an arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. If you must provide financial information and records so that your ability to pay any fees or costs can be reviewed and restitution. If you are referred for an evaluation or assessment by the probation department for any other kind of treatment or counseling or programming beyond that ordered by the court, you'll submit to that, and if there's a recommendation for programming, you're to enroll in and successfully complete that. You'll be required to pay the court costs of this action, make payment arrangements to do that. You'll be required to pay restitution through the victim escrow account in monthly payments. You say it's $200.
Yes, sir.
So it'll be $20 a month beginning June 1 of next year. So it gives you time to get through your treatment and transitional, get a job and get established. You're required to successfully complete the TCC substance use disorder treatment, and in the entry it's abbreviated as SUD, substance use disorder, and any recommended aftercare. Now, by being placed on community control, you're deemed to have consented to a search without a warrant of your person, vehicles, residence, or places where you're found or under your control at any time without a warrant. There will be no fine. There will be no driving suspension. You'll be ordered to pay the restitution dollars to Highland County Task Force through the Victim Witness Office and pay any fees they charge for that. Do $20 as a minimum. They charge, I think, $5 per transaction, so you're better off paying more if you can, so you'll have fewer payments or fewer fees. And you're also required to pay the court costs. If you don't do that, then those can be collected by the clerk through various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then they could also levy upon any assets or income that you may have. And if that doesn't collect it, the court could order you to do community service in this county and give you credit for each hour you work against that. And an hourly rate set by the court, each hour you work will reduce your judgment by that amount until paid in full. In the event that the probation department feels that you have failed to comply with these conditions, they'll file a written notice of the court. You'll get a copy. There will be a hearing. You'll be entitled to have an attorney. The outcome of that hearing is that you have failed to comply. And then at that time, the court will revoke your community control and sentence you to between 9 and 36 months of prison, fine you $10,000. If that occurs, once you complete that prison term, it is possible the Adult Parole Authority will put you under what's called post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a parole officer in the terms they set, and if during that period of time they determine that you have failed to comply, they could return you to prison to make you serve an additional period of up to 9 months for a single violation, or a cap of half of your prison term for all violations. But if you commit a new felony, then in addition to whatever sentence a judge in a new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, serve consecutively the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
All right, Then Mr. Wheaton, you need to report down to the probation department. You're no longer under a pretrial supervision, and then they'll talk to you about what you need to do after that. All right, thank you. All right, are you Craig A. Gerber?
Yes, sir.
All right, this is case number 17 CR 109. State of Ohio versus Craig A. Gerber. This is an evidentiary hearing being conducted by Zoom. Mr. Gerber is represented by Catherine Hapner, who's appearing from her office. Appearing on behalf of the prosecutor's office is Assistant Prosecutor King. Mr. Gerber was convicted of theft from a person in a protected class, a third-degree felony, and he was sentenced to community control on October the 5th, 2017. All right. Looks like on June the 15th of 2022, there was a warrant issued for his arrest, and that was served on October 31st of this year. And at that time, I think it was actually on the 2nd, the court notified Mr. Gerber of the allegation and set the matter for hearing today. All right. Now, Ms. Hapner, have you had an opportunity to talk with your client regarding these accusations?
Yes, I have.
And are you and he both in agreement this matter can be conducted by Zoom rather than an in-person hearing?
Yes, we are.
All right. And Mr. Gerber, you're okay with that as well?
Yes, sir.
All right. All right, and Ms. Hapner, is your client going to admit to any of these allegations, or are we going to have a hearing?
Your Honor, it's my understanding that my client will be entering an admission to violating rule number 1, rule number 2, rule number 15, and rule number 18, and that the state will be dismissing the alleged violations of rule number 3 and rule number 4.
All right, Mr. King?
That's correct, Your Honor.
All right, Mr. Gerber, the allegations that are being referred to were filed on October 31st, and they they allege violation of the conditions from the entry that was filed on October the 5th, 2017, which put you under 5 years of supervision, and then you were declared an absconder in June of 22, so that has not run since then. So Rule 1 alleges that you were convicted of a new felony in Montgomery County on 9/18/18 for non-support, which would be a violation of Rule 1. Rule 2, that you have failed to report when and as directed, and that alleges that you failed to report since May 6th of 2022. Rule 15, that you owe $141.99 of court cost. And Rule 18 required you to pay monthly payments of $200 in restitution. Says you have not made a payment since 3/24/22. So those are the ones that it's been suggested that you're going to admit. Now, do you understand those allegations?
Yes, sir.
And you do have a right to have a hearing in this matter in which the state would have to present testimony and evidence that proves to the court that you have committed these violations and not complied. You have a right to have your attorney cross-examine any witnesses the state presents. You have a right to present evidence on your own behalf, although you're not required to do so, and if you don't, it won't be used against you in any way. In the event that you're found to have violated these conditions, or you admit to the conditions on your own without a hearing, one of three things can happen. I can continue your community control under the same conditions previously ordered. I could continue it with additional conditions that I think are appropriate. Or the third and the most serious is I could revoke your community control and sentence you to prison for a period of between 9 and 36 months in the increments provided by law within those two ranges, and I could fine you $10,000. Now, do you understand the allegations against you?
Yes, sir.
You understand your rights?
Yes, sir.
And has anyone promised you anything to get you to admit to these allegations here today?
No, sir.
Has anyone threatened you in any way to get you to admit to the allegations?
No, sir.
Now, you understand the possible consequences if you're found to have violated these could include a prison term between 9 and 36 months.
Yes, sir.
Okay. All right. So, do you have any questions at all about any of your rights or anything I've explained to you here this afternoon?
No, sir, no.
All right, then is it your decision to admit to the allegations in the notice that was filed on October 31st, excluding Rule 3 and Rule 4 allegations which are dismissed?
Yes, sir.
All right. The court then will find that his defendant admits to those violations. All right, now anything from the state regarding disposition?
Yes, thank you, Your Honor. The state is requesting that the defendant's community control be revoked and that he be sentenced to a term of incarceration. At this point, I feel the defendant has shown that he's not amenable to community control. He has been non-compliant with the probation department for the past year and a half. He's not reported to probation since May of 2022. He's had a case for his arrest since June of 2022. At this point, he still owes over $9,000 in restitution, has not made a payment towards his restitution since March of 22. We'd also note that the victim in this case is monitoring the hearing of the Spring Park Highland County victim witness. The state has consulted with the victim, and she has indicated that she believes the defendant's community control should be revoked also. So based upon all of that, the state is requesting a term of incarceration. Thank you, Your Honor.
Yes, thank you. I apologize for not bringing it up before we started. I meant to, and I got sidetracked on other things. All right. Ms. Hapner, anything you would like to say?
Thank you, Your Honor. I did spend some time with Mr. Gerber. He has been incarcerated in Montgomery County Jail for, I believe, 240 days prior to being transferred to Highland County. So obviously during that period of incarceration, he could not have been reported here. He also indicates to me that he and his wife had some serious health issues that precluded him from reporting, and he was not able to work during that time period, therefore could not make restitution payments. He's also indicated to me that he has resolved those issues and he has gained employment, and if he were to be released and continued on community control, he would be able to begin making restitution payments immediately. He indicates to me that he has spoken with his employer about having those restitution payments withheld from his paychecks and sent in directly so that it would not be a matter of him needing to make payments, they would be made automatically. You continue to him on community control.
All right, Mr. Gerber, anything you would like to say?
You know, like I said, I wrote you back in July. Everything I said in that letter was true. I know it may not seem like it, but this last 8 months of my life, I needed it and got my head on straight. All I care about doing now is getting this lady taken care of. And if I'm given the opportunity, I will not go get it. I do have a very stable job. I'm going to stay at my mother's house until I get her taken care of. I've already set myself up. That way I can have everything taken care of, get her taken care of. And just move on with my life. I'm just trying to get everything done right and show you and her and everybody else that I have learned my lesson. I'm trying to do what is right by the victim. Thank you, Your Honor.
Why were you in jail in Montgomery County?
I was on probation in Montgomery County and I was in jail.
For the non-support?
Yes, sir. And what happened was my wife was in the hospital.
No, I just want to know how long you were in the jail. So you were in the jail for non-support for 270 days.
Yes, sir.
All right, so you're done with probation there.
Yes, sir.
All right. All right. Well, I noticed in this that we had hearings on the restitution back in 2020, and I believe I ordered them to pay $200 a week, or $200 every 2 weeks, because I think at that time that's what Mr. Gerber indicated he can do. And that was February the 20th, 22. And the documents filed didn't show any payments. And I don't have, how many payments has he made since that time, or how much has he reduced the restitution by since that time, Mr. King? I think at the time in 2020, the balance was $10,974.33.
That's correct, and now the balance as of today's date is down to $9,929.33, with the last payment being in March of 22.
$9,929.
33.
All right, so that means he paid about $1,000 from that time until he was brought before the court. All right. Well, Mr. Gerber, you know, this is a third-degree felony. You have committed against a vulnerable person. I need a jail time credit, Ben. Okay, you committed this offense against a vulnerable person. You have been given the opportunity for community control 5 years ago, and in that period of time, you paid a very small amount of restitution. You were convicted of another offense. You didn't make payments. You quit reporting over a year ago, almost a year and a half ago. And so it's a finding of the court that you're not amenable to community control. So the court is revoking your community control and ordering that you be sentenced to the Correction Reception Center at Orient, Ohio for a period of 18 months. You have credit, according to the sheriff, for 14 days since you've been brought back. Well, actually, I was printed on the 14th, so today's the 16th, so 16 days of jail time credit. Now, upon completion of the prison term, it is possible the Adult Parole Authority will put you under what's called post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised under the terms they set by a parole officer, and if you fail to make those, comply with those conditions, they could return you to prison, make you serve an additional period of up to 9 months for a single violation, and that's also the cap for all violations. However, if you commit a new felony, in addition to whatever sentence a judge in the felony case can impose upon you, the judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively as sentenced in the new case. Now, you're also ordered to pay the court cost, and if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of the prison term, not while you're in prison, but once you get out, the court could allow you to do community service and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, the restitution order still remains because that's part of the original sentence, and it's still a substantive order. So even though if you serve all the time that's indicated in the court's order, you will not be relieved of that obligation. You'll be required to pay it no matter what happens. And if you fail to do that, you can be brought back to court like you were previously while you were still on community control for a hearing to determine if you have the ability to pay. And if you fail to do that and you had the ability to pay, that could constitute contempt of court, and subject you to incarceration for that. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded to custody then. All right. All right, this is case number 20 CR 99, State of Ohio versus Dalton Garland. Mr. Garland, Miss Barger did not log in, and she's not responding to our phone call, so I don't know what's happened. I think there must have been a mix-up on her end, or perhaps we didn't get her the notice. I don't know which. Has she been out to see you?
No, Your Honor.
All right, well, I'm going to say we may not have gotten the word to her, so we're going to go ahead and track her down, and I'm going to have to continue this. We'll see as soon as we can find out if she's available. Possibly can get it done tomorrow, or if not, Monday. So as soon as we can find her, we'll get you back on the docket. Okay. All right. Thank you. All right. Credit. Do you have the?
It should be in the probation.
Oh, that's right, because we continued this, didn't we?
Yes.
Yes. Yep, there it is. All right, this is case number 23 CR 134, State of Ohio versus Joshua Queen. Present for the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Danielle Witt. And are you Joshua Queen? Yes. All right. Mr. Queen was indicted for aggravated possession of methamphetamine, a fifth-degree felony. He filed his motion for intervention in lieu of conviction, and I believe we had to postpone this hearing because he had not yet been evaluated. I now have a statement, or was it because of drug use? It was because of drug use. Yeah, I continued it till November 8th, and then I received a report said he has been compliant. And I see here, Mr. King or Queen, that you applied for or you were asked for a urine screen on the 9th, which would have been last Thursday, and you refused. And you said you were tired of screening and had to screen in 4 days. And then the probation department indicated that you screened on the 14th positive for marijuana, THC. So I think we talked about this at the last hearing, and I think I said I needed to get a clean screen from you. And, you know, as a clinician indicated to you, if you're refused, that's considered a positive result. And then you did test positive for THC, and you can't have any drugs of any kind, including marijuana. So I'm wondering if we even need to, why should we go through with this? you know, if you can't stay clean. Because you're not gonna make, one of the conditions is you have to stay clean unless you have a prescription for 1 year. And you haven't stayed clean at all yet. So I'm thinking he needs to be reevaluated for residential treatment. So I'm gonna continue this one more time. I want you to go down to the probation department. I'm gonna call Miss Sturgill and tell her what we're looking for. I don't know if she'll be able to see you or Miss Davis, but they will talk with you and see if that's something that might need to be, because as of the 31st, you were positive for amphetamines, methamphetamine, and THC. Before that, you'd just been screening positive for THC. So, and then in your attitude, saying you're tired of screening isn't going to be good, because you're going to be screened, whether you're tired of it or not. If you don't, you're going to be revoked, and you're going to get a conviction anyway. And with that kind of an attitude, you're probably not, going to end up doing some jail time. So I think you better think about getting clean and perhaps residential treatment. So we'll continue this until December the 5th at I forget what time we're doing those hearings. Would you go grab the calendar, Ben?
Your Honor, do you mind if I grab my calendar?
Sure.
Sarah said who?
Huh?
Sarah's like, who? Well, I checked, I emailed her.
Yeah. She just did.
She was sick.
She just skipped it.
Yeah.
Yeah. Okay. So when's she gonna feel she'll be
She
there?
hasn't, she's responded. She said, there it is. There's her message.
Yeah.
Oh, now she's trying to call me.
All right.
Do you want to do it here in a minute, if I can get her on there?
No, we've already let everybody go.
Okay.
Yeah, and she's sick. We don't need to.
Okay.
She's not met with the guy.
Oh,
So she needs to tell her to get it, and when she gets feeling better, hopefully over the weekend, go see him. We'll go ahead and schedule for Monday.
Monday, okay.
Monday or Tuesday, because
Okay.
tell her we got a bed date for
Bed
her
on
on Wednesday.
Okay.
Yeah. Let's see, Tuesday's grand jury, so 2:30? That available? All right. Now, Mr. Queen, need to continue to report, and like I said, I think you need to reevaluate what's going on here, because this is an opportunity for you to get into treatment and avoid having a conviction. And here you go, Marcia, and put that in the PSI file. If you don't take this seriously, you're going to lose that. You're just blowing it, and then you got no one to blame but yourself. And so, I'm not an expert. I'm not, but I've got a lot of experience, and given what's going on, I'm thinking that you might be a candidate for residential treatment or intense outpatient treatment, meaning 3 to 4 days a week. How often are you going right now? Once? Yeah, that's not going to cut it. You're not, because you're still using, and there's no point in me giving you this when I know that you're going to violate within the first 2 weeks and be right back here. So, you're not doing anything other than kicking the can down the road unless you take some serious steps. So, you go down to the probation department and tell them that I continue this because you tested dirty again, and that you need to consider whether you should get checked into a residential program, so that you can get this behind you. If it was only marijuana, I wouldn't be quite so concerned, but, you've also been using meth, and I expect that's why you declined to be tested last week, because you thought it was going to pop again on meth and amphetamine. So, I don't want to see that happen to you, but you got to get yourself together. All right, so he'll give you an assignment notice and then you go down probation. All right, this is case number 23 CR 193, State of Ohio versus Travis James Zuber. Are you Travis James Zuber?
Yes, sir.
All right. Mr. Zuber, you were indicted by the grand jury back on October the 3rd. You were indicted on a charge of engaging in a pattern of corrupt activity, a first-degree felony, which alleges that you, on or about a period of between May 1, 2020 and October 2, 2023, along with Justin Kyle Anderson and other unindicted co-conspirators did engage in directly or indirectly in an enterprise through a pattern of corrupt activity. At least one of those was a first, second, or third degree felony. So that's a first degree felony. It has a mandatory sentence of between 3 and 11 years as set by the judge, with a possible additional 1/2 of that sentence being added by DRC at their, based upon their analysis of your case, and a fine of $20,000. You were also indicted in count 25, which alleges that on or about May 19, 2022 in this county, that Justin Kyle Anderson, you, Bridget Brooks, Aubrey Utley, and Richard Scowden did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute hashish in liquid form with an amount equal to or exceeding 400 grams when you knew or had reasonable cause to believe it had been intended for sale or resale by you or another in the vicinity of a school zone. And in count 26 alleges on about that same date you possessed that. And that is count 25 is also a first degree felony. Same penalty as count 1, and count 26 is a second degree felony. And it has a possible penalty of between 2 and 8 years mandatory, and a maximum of half being added onto that, and a fine of $15,000. Both of those carry possible license suspension of 6 months to 5 years. Now, it's my understanding that you have hired, or you are in the process of hiring Mr. Justin McMullen. Is that correct?
Yes, sir. I had him on retainer, and I am going to hire him, though, I believe.
Okay. Well, he indicated that it not yet was not yet ready to enter an appearance because he hadn't apparently confirmed the payment. So at this point, I'm just going to go ahead and enter a not guilty plea on your behalf.
Thank you.
And I'm going to set bond in the amount of $50,000 plus an OR bond, which is your promise to pay. And if you fail to pay, you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case. Now, we're going to set a bail review hearing for you on Monday, which would be November the 20th at 8:30, and that'll be by Zoom. That's to review your bond with counsel, so hopefully you'll have your arrangements made by the end of the day or tomorrow, and you'll need to notify him of that so that he can participate, or if he's not able to participate and wants to continue it, we can do it. We do those by Zoom, so he won't have to come down here from that, because I see he's from Columbus.
Yes, sir. Thank you.
Set your first pretrial for December the 13th at 1:00 p.m. And that can be by Zoom as well. We'll have a final pretrial on January the 3rd at 1:00 p.m. And the trial date, let's see here. You know where my October sheet is, Ben? Do you have yours there? Wait a minute, I just found November, so maybe October's here. Never mind, here it is. September was on top of it. All right. we'll set the trial date then for January the 8th at 8 a.m.
Yes, sir.
Now, in addition to $50,000 bond, you'll be required to pay a service fee of $116 prior to release. You'll be under pretrial supervision if you do make the bond at 117 East Main Street, so you'll report to them immediately upon release, and then after that, once a week for 4 weeks after that, as they determine, undergo random drug tests they may order, provide phone numbers for home, cell, and employer, have no contact with any of the co-defendants. You're recommended by probation. You'll be evaluated for substance abuse and mental health issues. If any treatment is indicated, you enroll in and follow that during the pendency of this action. What is your address, Mr. Zuber?
5737 St. Clement Court, Toledo, Ohio, 43613.
San what?
St. Clement?
St. Clements. All right.
No S, CLEMENT.
Okay. And
Yes.
what is its city or town?
Toledo, Ohio, 436.
Okay.
Yes, sir.
All right. So you'll have to be under house arrest at that residence unless you're working, going to and from work, medical appointments, court proceedings in this or any other case. You can also attend any kind of hearings or appointments with an attorney or court hearings. You may also attend any kind of job training, educational programming, church services, and family holiday events. In the event that you fail to comply with these conditions, then the court could revoke that bond and have you held till further order of court. So
Yes,
it's
sir.
up to you to notify Mr. McMullen, because he's not yet entered an appearance in this case, so he's currently not your attorney until he enters his appearance. So you get a hold of him, let him know about the hearing Monday. All right?
Yes, sir.
All right. Thank you.
Thank
All right, then, Mr. Lothan. All right, are you James E. Lothan?
Yes, sir, I am.
Is that how you pronounce that, Lothan?
It's Louthan, sir, but
Loughton? Okay, Loughton. All right. This case number 23 CR 211, State of Ohio versus James E. Loughton. Mr. Loughton is appearing from the jail by video. He was indicted by the grand jury on November the 7th on a charge of receiving stolen property. Assistant Prosecutor King is present for the arraignment, and Mr. King, has the alleged victim of this offense been notified of the time, place, and purpose of this hearing and the right to be heard?
Yes, sir, Your Honor, the right not to appear.
All right. All right, Mr. Lothan, the indictment alleges that on or about June 4, 2023 in this county, you did receive, retain, or dispose of a 2022 Ford F-450 truck with a dump bed, a motor vehicle belonging to another, and that you knew or had reasonable cause to believe that had been obtained through the commission of a theft offense. Now, you are entitled to have an attorney to represent you in this matter. If you can't afford to hire one, the court will appoint one for you. So you did fill out a financial statement. Is everything on this correct?
in terms of the financial statement, yes, sir. I'm getting sentenced in Hamilton County. I turned myself in. I called the sheriff's
Okay, well,
department.
wait a minute. Wait a minute, okay?
Excuse me, sorry.
I asked you a question, I'll get to the other matters here as we can. Is this the first time you've been in court on this case?
Yes, sir.
When were you in court on this case before?
I have never been in court on this case.
Okay, that was my question, okay. I was just wanting to know if you had previously had an attorney to represent you in this matter, in this case. All right, so since that has not occurred, I will appoint Attorney Jacob Wagner of Hillsborough, Ohio, to represent you. And in the absence of counsel, I'll enter a not guilty plea. When are you scheduled to be sentenced in Cincinnati?
12/7.
And what is the charge down there?
It's possession. My probation officer's name is Destiny Harris.
What is the charge that you are facing down there?
Possession.
Okay, a 5th-degree felony?
5th degree felony, I believe so, yes.
All right.
I'm getting it dropped. I'm
All
having
right, now,
it in treatment.
just answer my questions. Okay.
I'm sorry.
All right, we'll set a bail review hearing for you if you don't make bail for Monday, the 20th at 8:30 a.m. That'll be by Zoom. We will set your first pretrial for December the 13th at 1:00 p.m. Your final pretrial will be January 3rd at 1 p.m. And your trial date will be set for January the 25th at 8 a.m. You served a previous prison term?
I have not been served prison time in this state. I have not. I've done one county sentence where I showed up to court on a review hearing.
All right. The court's going to set bond in the amount of $5,000 plus OR, which is your own recognizance, and that's your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. And if sentenced, or if convicted, sentenced on that, no matter what happens in this case. If you do make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. And you'll report there immediately upon your release, and then once a week for 4 weeks after that as they determine. Undergo random drug testing they may order, provide phone numbers for home, son, employer, not have any contact with the alleged victim, be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of educational classes, programming, GED, college classes, etc. You can attend church services and any family holiday events. You'll have to go directly to and from those activities. If you fail to comply with these bonds conditions, then that could be revoked and you could be held till further order of the court. All right, we'll notify your attorney of his appointment. We'll have a review of your bond hearing on Monday morning. Do you have any questions?
Yes, sir. Since I notified the sheriff's department and my PO and everything of my indictment, they didn't even see it on the file. I just wanted to put that on the record that I did talk to the chief at the sheriff's department here. I called, they made it aware of my address and that I was on house arrest for pretrial sentencing.
You have a question? You're making another statement. You have a question?
So how much is my bond?
$5,000 plus an own recognizance and a $171 deposit. All right, anything else?
Okay.
Any other questions?
No, thank you.
All right, thank you.